Welcome to the Deep Dive. Today, we are strapping on the headlamps and tackling a topic that, well, many of us instinctively shove into the too hard, too complicated drawer, estate planning. It's one of the most vital acts of love and responsibility we can perform for our families, yet the confusion around wills, trusts, and powers of attorney is just so overwhelming that people put it off indefinitely.
And that delay, as we'll discuss in great detail, is exactly what guarantees heartache, massive expense, and legal conflict down the line. Our mission today is not just to define terms, it's to clear up the confusion surrounding the process.
Okay.
We are going to distill the fundamentals, demystify the essential legal documents, the 5 pillars of any good plan, and give you a clear, actionable, 7-step process for securing your wishes.
So this is like the shortcut.
Think of it as your shortcut to understanding a crucial lifelong responsibility.
Yes, absolutely. And we're drawing our insights from some really comprehensive guides on estate planning. We've got detailed breakdowns of how different trusts actually function, the practical consequences of not planning, and even some crucial cost comparisons for professional help.
Yeah, because that price tag is often what stops people.
Right.
The big picture takeaway right out of the gate is this, and we cannot stress it enough. Estate planning is not just for the ultra-wealthy.
Not at all.
It is essential for everyone who owns assets or has people who rely on them. It's fundamentally about organizing your financial and personal affairs, minimizing potential taxes and fees, and most importantly, ensuring your loved ones are protected from agonizing legal disputes.
It's about peace of mind.
We are talking about true peace of mind.
So let's start with the absolute basics, because you can't really plan an estate until you know what an estate actually is.
Yeah,
I think when we hear the word estate, a lot of people picture, Downton Abbey or vast vineyards.
right, something grand. But what we're really talking about is everything you own, period.
Everything.
Everything. Your estate is the collection of all your belongings, your assets, your liabilities. This includes the big stuff, like your home, any investment properties, cash, bank accounts,
Your car.
your car, investment accounts, all of that. But it also includes items you might forget, things like antiques, artwork, valuable collectibles, sentimental family possessions.
What about the assets that are, increasingly important in the modern world? The digital stuff.
Absolutely. We have to include digital assets. That means cryptocurrency holdings, domain names, intellectual property like copyrights, and even the value held in certain online accounts.
Wow.
An estate is really just a comprehensive snapshot of your financial and personal universe.
So if that's the estate, what is the core purpose of putting together a plan? I mean, beyond just passing on money, what are we trying to achieve here?
Well, the purpose is really threefold. First, it's about control. You're guaranteeing your assets pass on exactly as you intend, not according to some default state law.
Okay, control.
Second, it's about protection. Specifying your healthcare and long-term care wishes if you become incapacitated and, you can't speak for yourself.
And the third.
And third, and this is critically important for parents, it's where you legally name guardians for minor children or specify care plans for dependent adults or even your pets.
Okay, so you said everyone benefits from a plan.
Mm-hmm.
Well, let's give our listeners some practical markers, like these specific situations where planning moves from a good idea to an absolute non-negotiable necessity.
Right. So if you're an adult, regardless of age, you benefit from a plan because you need to appoint someone to make medical decisions if you can't. But the necessity, it really escalates quickly in a few scenarios.
Like what?
First, if you have children or grandchildren, especially minors, that's number one. Second, if you own a business or any real property, a house, land, even a car, anything that has a title.
Yep.
Third, if you have a blended family, second marriages, stepchildren, complex family dynamics. Without a plan, those intestacy laws we mentioned often prioritize biological ties in a way that can completely exclude stepkids or secondary spouses.
That's a huge point. So if your plan is to make sure your second spouse and your kids from a first marriage are both taken care of.
State law will likely ruin that intention.
Wow.
Precisely. Also, if you have family members with special needs who rely on government benefits, a plan is crucial. You can set up a special needs trust to provide for them without disqualifying them from necessary aid.
Okay, that makes sense.
And finally, if you own assets and investment accounts, retirement plans like a 401k or IRA, or even if you just have a pet. The guardianship planning for pets alone is a huge motivator for a lot of people.
Okay, let's unpack the existential threat here. What happens when you die without clear direction? That dreaded term, dying intestate.
Dying intestate simply means you passed away without a valid, legally executed will, and when that happens, you lose all control.
So your wishes just
Yeah.
don't matter.
They don't. Your entire estate doesn't go where you might have wanted. Instead, it goes through a court-managed process called probate. And in probate, the distribution is dictated entirely by your provincial or state laws of intestacy.
I've heard those laws are very rigid. Can you give us a common example of how those laws can go completely against what a normal person would actually want?
Yeah, the most common and frankly painful example involves married couples with children. Most people assume if they're married, their spouse automatically inherits everything.
Right, that seems logical.
It does, but it's often not true. In many jurisdictions, if a person dies intestate, the law splits the estate between the surviving spouse and the deceased's children, even if the children are adults.
Wait, so the spouse might suddenly own the family home with their own kids as co-owners.
Exactly. The spouse may only get half or a certain fractional share, and the children inherit the rest. This creates a nightmare scenario where the surviving spouse might not have enough cash to live on, or they might need their kids' consent to sell or remortgage the home.
That is genuinely shocking.
The laws of intestacy just override the personal, emotional logic of the family unit.
And that's just the financial side.
That's just the money. The consequences go beyond that. The court has to decide the guardian of any minor children. They'll hold hearings, examine relatives, and decide who they believe is fit all without any input from the parent who passed away.
That alone should be the single loudest alarm bell for every parent listening right now.
It really should be. Providing certainty about who will raise your children and how they'll be provided for is probably the most compelling reason for any parent to have a will. Dying intestate causes so much unnecessary anguish and crucially massive conflict among family members who will inevitably disagree on how things should be split up.
You're basically forcing your family to hire lawyers and fight in court.
That's exactly what you're doing.
So we've established that the nightmare scenario, dying intestate, forces your estate into this public, costly, and rigid legal machine called probate. Let's nail down exactly what that machine is, because avoiding it seems to be one of the main goals here.
It is. So probate is the official legal court proceeding that validates your will, if you have one, and then formally transfers the property of the estate after your death.
Okay.
Its main purpose is to make sure all outstanding debts are paid and assets are distributed correctly, either according to the will or, if that isn't one, according to that intestacy law.
So it's the official closing and distribution process, and a judge is watching over the whole thing. What are the key steps the court oversees?
Well, there are 4 main steps, and this process can take months, sometimes years, to execute.
Wow.
Step 1. The court officially appoints an administrator or validates the executor named in your will, giving them the legal authority to act. This person then takes over management of everything.
Which means they start the process of what? Hunting for all the accounts.
Precisely. Which leads to step 2.
Right.
The administrator or executor identifies and inventories all of the deceased person's assets, figuring out their value at the time of death. They have to notify creditors, too, often by placing public notices.
Okay, so inventory and notify.
Step 3. They pay off any outstanding debts or taxes owed by the estate. This is where state-level inheritance taxes, federal estate taxes, funeral expenses, all the outstanding bills, everything gets settled.
And then what's left over goes to the family.
That's step 4. They distribute the remaining assets, what's called a residuary estate, to the proper beneficiaries, either according to the will or those intestacy laws.
That sounds like a long bureaucratic headache.
Yeah.
And in the legal world, time. Well, that translates directly into cost, doesn't it?
It absolutely does. Probate is notorious for being lengthy and costly. The fees just stack up: court filing fees, legal fees, executor fees, appraisal costs. We saw data showing that without a clear plan, the process can easily drag on for 18 months or even 2 years.
2 years.
And the fees are increasing that entire time.
And you mentioned a financial hit that was substantial. More than $12,000 in legal bills on average. Where does that money actually go?
A huge chunk goes to the attorney's fees for guiding the executor through all the intricate court filings, the required notices, the accounting. The rest goes to the court itself: filing fees, certified copies, administrative costs. And on top of that, if the executor spends a lot of time on this, they are typically entitled to a commission or a fee, which comes directly out of the estate funds before anyone else gets a dime.
So it's a tax on being disorganized.
It's a very costly tax on disorganization.
And beyond the money and the time, there's a massive privacy concern here that I think a lot of people overlook.
This is a crucial point. Because probate is a court process, the proceedings are public record.
Public record.
Yes. This means that anyone, your neighbor, a nosy relative, a scam artist, anyone can go to the court clerk's office and access information about the deceased person's assets, their debts, and the specific names of the beneficiaries who inherited what.
So if you value privacy about your finances and who gets what, avoiding probate is mandatory. You do not want your entire financial life laid bare for the world to see.
Exactly. It reveals details you might prefer to keep confidential, especially around family dynamics or the specific value of your holdings.
Okay, so if probate is the beast we need to avoid, what is the primary tool available to us, regardless of our estate size, to bypass this whole lengthy, costly, and public process?
That tool is the trust. Specifically, the living trust. When you transfer assets to a trust during your lifetime, those assets are technically owned by the trust, not by you personally. So when you pass away, the assets in the trust don't need the court's permission to transfer to your beneficiaries.
So it happens privately.
It happens privately, instantly, and without the hassle of probate. It saves your family massive amounts of time and money. And trusts are available for estates of any size. They're incredibly powerful instruments for probate avoidance.
Okay, so we've defined the problem: probate and intestacy, and the goals: control and privacy. Now let's drill down into the building blocks. A truly comprehensive estate plan rests on 5 essential documents that cover 3 distinct periods: during your life, during incapacitation, and after your death.
Right. And we'll start with the document most people are familiar with, but whose function is often misunderstood, especially in relation to a trust. And that's the last will and testament.
Okay, so define the will for us. What are its core functions?
It's the foundational legal document outlining how your assets should be distributed after your death. It really has 3 critical jobs. First, it dictates who gets what. Second, it names an executor to administer the estate.
And third?
And third, it names guardians for any minor children. It is the final word on who gets what and who's in charge of making it happen.
But wait, if we want to avoid probate, why do we need a will at all if we're using a trust?
That is a fundamental question. A will only goes into effect after death, and it must go through probate to distribute the assets it covers. A trust, on the other hand, can take effect during your lifetime, and it avoids probate.
So why have both?
You need a will for 2 key reasons. First, a will is where you legally designate guardians for minor children. A trust can't do that.
Ah, okay, that's critical.
It is. And second, you use what's called a pour-over will. This will basically says, if I forgot to move any asset into my trust while I was alive, pour that forgotten asset into the trust upon my death.
So it's like a safety net.
It's a safety net for any missed details. Now, that forgotten asset still has to go through probate, but the will ensures it ultimately ends up governed by the private terms of your trust.
So the trust is the main tool, and the pour-over will is just for cleanup.
Absolutely correct. A trust is for asset management and probate avoidance. The will is for guardianship and that final cleanup of the estate.
And since life is always changing, how often should this foundation document be looked at?
You should view the will as a dynamic, living document, not some one-and-done formality. You really should review and update your will whenever a major life event occurs.
Like what?
Marriage, divorce, the birth or adoption of children, retirement, buying or selling a big asset like a home or a business.
Yeah.
Or the death of an executor or a beneficiary.
And if nothing changes?
Even if nothing major changes, an annual or biennial review is still a good practice just to make sure it reflects your current reality.
Okay, moving on to trusts. We identify them as the primary tool for avoiding probate and gaining privacy. Let's look at the different categories, starting with the flexibility distinction. Revocable versus irrevocable.
A revocable living trust is the most common tool. The grantor, that's the person setting it up, can amend it, change the beneficiaries, or revoke it entirely at any point during their lifetime, as long as they're competent.
So it offers maximum flexibility.
It does. It's the standard instrument for probate avoidance for most people.
And the irrevocable trust, what's the trade-off there?
An irrevocable trust is set. It generally cannot be altered once it's established. The trade-off is significant. You give up control, but in return, the assets you place in that irrevocable trust are usually shielded from creditors and potentially excluded from your taxable estate.
So that's more for high net worth individuals doing complex tax planning.
Exactly. For most people, the revocable living trust is the answer.
So let's focus on that living trust. What are its main benefits besides avoiding the nightmare of probate?
Well, a living trust is established during your lifetime. And beyond probate avoidance, it's excellent for managing incapacitation. If you become ill or disabled, the successor trustee you named steps in seamlessly to manage the trust's assets, paying bills, handling investments, without needing a court-appointed conservator.
So it provides that continuity of management.
It does.
Now, we've seen that many parents use a special kind of trust specifically for minor children. Can you talk about the testamentary trust?
Yes. A testamentary trust is unique because it's created after your death by the terms you set out in your will.
So it's funded through probate.
Usually, yes. Parents use this because children can't legally inherit large sums of money until they reach the age of majority, which is often 18 or 21.
So what does this trust actually achieve?
It allows the parent to name a trustee, an adult they trust, to administer those funds on the child's behalf for specific purposes, for healthcare, education, general welfare.
And you can set the timeline.
Critically, the parent can specify the age at which the child gets full control of the assets. It could be 25, 30, or even in stages. This prevents a young adult from inheriting a huge sum of money before they have the maturity to handle it.
That's fantastic control. Instead of the state handing over a giant check on their 18th birthday, the parent's wishes govern the timeline.
Precisely. The overall goals of trusts, therefore, go far beyond avoiding probate. They are tools for managing taxes, designating specific heirs, caring for special needs children, and setting guardrails around inheritances for younger beneficiaries.
Excellent. So wills and trusts handle the after I die part, focusing on assets. Now we pivot to the while I'm incapacitated part, starting with the financial and legal authority, the power of attorney, or POA.
A POA is a foundational legal document. It grants someone, called the agent or attorney in fact, the legal right to make decisions on your behalf. If you're incapacitated, this document ensures the bills get paid and your investments are managed.
You sourced 5 key types or distinctions of POA, which that complexity alone highlights why professional guidance is so essential. Let's break them down.
Okay, first we can distinguish by function. The financial POA lets the agent make financial decisions, and the healthcare POA lets them make medical decisions.
This is simple enough.
Second, we distinguish by durability. The non-durable POA is only for a specific period or transaction. It expires if you become incapacitated.
So not very useful for planning.
Not really. The durable POA is the critical one for estate planning. It remains in effect if the principal becomes incapacitated, ensuring your affairs continue to be managed without court intervention.
And what about timing? When does that power actually kick in? This seems like the trickiest distinction.
It is, because it involves a major trade-off between control and convenience. The immediate POA grants power upon execution. The agent can act right away. This offers the greatest speed and certainty, but it requires absolute 100% trust in the agent from day one since they have legal access to your funds while you're still fully competent.
That sounds incredibly risky if you choose the wrong person.
It is a high-trust document. The alternative is the springing POA. This power springs into effect only if you become incapacitated, usually based on a doctor's letter or a legal finding of incompetence.
That sounds safer.
It offers greater protection because the agent can't touch your funds while you're well, but it can lead to frustrating delays.
Delays? Why? Doesn't the doctor just sign a form?
Not always. If the document isn't perfectly drafted, or if the standard for incapacitation is vague, banks or financial institutions might refuse to honor it. They might demand a specific court order, which defeats the entire purpose of avoiding court in the first place.
So that definition of incapacitated has to be crystal clear.
Extremely clear in the POA document itself.
So agent selection is clearly the most massive responsibility here.
It's critical. You have to appoint a competent person over 18, and ideally someone who is physically accessible and financially responsible. A poorly drafted POA or a poorly chosen agent is useless right when you need it most.
Okay, finally, let's talk about the last 2 documents, which relate purely to your physical self, the living will and the advance directive.
This is where we discuss end-of-life autonomy. The living will, which is often part of a broader advance directive, is a legal document that expresses your specific wishes regarding end-of-life medical treatment when you can't communicate them yourself.
What are the specific instructions this document can include?
It outlines your preferences if you're in a terminal condition, a persistent vegetative state, or an irreversible coma. It includes preferences regarding life-sustaining measures. Do you want CPR? Do you want a DNR, do not resuscitate order? Do you want mechanical ventilation, tube feeding?
All the really tough decisions.
It also covers pain management, palliative care, and organ donation wishes.
Why is this so crucial, emotionally speaking?
It eliminates uncertainty. It prevents your family members from being forced to make these high-emotion, gut-wrenching decisions about ending life support while they're grieving. It ensures your personal values and dignity are honored, even if you're unconscious.
So, to make the distinction crystal clear again, what's the difference between a healthcare POA and a living will?
The healthcare POA names who makes the medical decisions on your behalf. It grants decision-making authority. It's flexible and applies to almost all medical situations.
So, the who.
The living will dictates what those decisions should be regarding life-sustaining measures, and only when specific end-of-life conditions are met.
The what?
Exactly. You need both. The will provides the instructions, and the POA provides the voice to carry them out. And just like the financial POA, these medical directives need to stay current. Healthcare technology and laws change constantly.
We've now broken down the 5 foundational documents. The challenge for the listener, though, is turning those concepts into a cohesive, actionable plan. So let's walk through the 7 essential steps of preparing and maintaining an estate plan. This is the hands-on section.
Okay. Step 1 is the foundation. Inventory all assets and liabilities. This sounds simple, but it's often the most tedious and frankly revealing step. You need a comprehensive physical list of everything you own and everything you owe.
Let's list the common assets, but maybe also hit the ones people tend to forget.
Okay, common assets. Real estate, vehicles, traditional bank, and savings accounts. Then you move into the investment and retirement vehicles, pensions, IRAs, 401ks, health savings accounts.
And you need all the account numbers for those.
You must track the account numbers and current beneficiaries for all of them because those beneficiary designations often override what's in your will.
Oh, that's a key point.
It is. The often forgotten list includes business interests, life insurance policies, and paper certificates like treasury bonds or stock certificates.
And the modern challenge.
Yeah.
Digital assets. This is the new frontier of complexity, isn't it?
It really is. You must list your digital assets. This includes cryptocurrency wallets, digital safe deposit box passwords, specific login credentials for high-value accounts, even social media accounts or domain names that might have value.
And you can't just write passwords on a sticky note.
Please don't. You should use a secure, encrypted system for recording passwords and make sure your executor knows how to access it after your death.
So step 1 requires more than just a list.
You have to gather the supporting documentation, too. Deeds, titles, loan agreements. This is mandatory if you plan on opening a living trust, because you need the original legal documents to retitle them into the trust's name.
So once we have the inventory, step 2 is creating the last will and testament. If we're using a trust, what specific action items do we focus on in the will?
You focus on the assets that either won't go into the trust or the residual assets. Things like cash for immediate expenses after death, non-sentimental personal property, and those retirement plans we mentioned that already have named beneficiaries.
Now, the most important job here is picking the right people.
That's it. You elect the estate executor, who carries a heavy legal and fiduciary duty to the beneficiaries.
What makes a good executor? And why should we name a backup? Or 2?
A good executor is someone trustworthy, capable of managing complex financial tasks, and ideally someone who lives locally. It's highly recommended to choose 1 or 2 backup executors. The fiduciary duty is immense. They have to act in the best financial interests of the beneficiaries, not their own. They can be sued if they fail.
And of course, the emotional decisions about guardianship.
Yes. For minor children, you choose a guardian, again with backups, and this decision should be made in consultation with the people you name to make sure they're willing and prepared. This is all stuff you must do with a qualified lawyer to make sure it's legally valid.
Okay, moving to step 3. Creating and funding a living trust. This is how we avoid probate. What assets should typically be moved into a trust?
Assets that should be owned by the trust are those that are subject to probate. So, real estate, investment accounts, major business interests, and any highly valuable personal property like a significant art collection.
And when you're drafting it, you're picking the beneficiaries and a successor trustee.
Correct. The successor trustee is the person who takes over if you die or become incapacitated. You should choose them with the same care you used for your executor.
But the critical step, which you said is where most people fail, is actually funding the trust. What does funding entail logistically?
Funding is the process of legally transferring assets from your name to the legal ownership of the trust. A trust is just a piece of paper until it actually holds assets.
So if you draft a beautiful trust, but forget to fund it,
it is functionally useless for avoiding probate.
Can you give us a concrete example of funding a major asset, like the family home?
Sure. If your home is currently titled in your name, John Smith, You have to execute a new deed, a trust transfer deed that retitles the property to read, for example, John Smith, trustee of the John Smith Revocable Living Trust, dated January 1st, 2024.
And that has to be legally recorded.
It has to be done with your lawyer and then recorded with the county recorder's office. For bank accounts and brokerage accounts, you have to go to the institution and change the official ownership records from your name to the name of the trust. It's an administrative headache, but if you skip it, that asset will go through probate.
So the value of the trust is equal to the diligence you put into retitling every single asset.
Absolutely. Zero diligence equals zero benefit. And you must consult a lawyer for this stage.
Next, we address incapacitation with steps 4 and 5. Designing powers of attorney, financial and healthcare proxy.
Right. First, you choose your trustworthy agent. Then you determine the scope of their power. Are you granting broad powers to manage everything or limited powers for specific transactions?
And this needs to be tailored.
Yes, you work closely with a lawyer to tailor the document, especially if you have complex assets. The POA document has to grant specific powers, like the ability to sell real estate or access digital accounts, or those institutions might refuse to honor it.
For the healthcare POA, the conversation with the agent is just as important as the paperwork, isn't it?
That conversation is non-negotiable. You have to discuss your specific values and wishes with your agent, your preferences on aggressive treatment, your tolerance for pain management, any religious considerations. Your agent has to understand your philosophy to be your true proxy.
And once these POAs are drafted and signed, you have to tell people.
Notification is key. You must immediately notify the agent of their appointment, review the document with them, and give them copies. For the healthcare proxy, it's highly recommended you notify your primary doctors, your local hospital. Maybe even put a note in your wallet stating who holds your POA.
Okay, that brings us to step 6, designing the Living Will Advance Directive.
This is the formalization of your end-of-life decisions. You'll typically use a state-suggested form or a lawyer-drafted document. You fill it out to describe your specific wishes regarding life-sustaining care, mechanical ventilation, tube feeding, resuscitation.
You're specifying exactly where you draw the line.
Exactly. For instance, you might say you don't want permanent life support if you have an irreversible condition, but you might consent to it if there's a chance of recovery. Every preference has to be detailed.
And similar to the POA, this document needs to be widely shared.
Yes. Discuss these wishes with your doctors, share the document with your loved ones, and make sure your designated healthcare proxy has the official signed copy. This document typically requires 2 witnesses, and you have to check your state's laws. Some states prohibit immediate family from being witnesses.
To avoid any conflict of interest.
Right.
And finally, the often neglected step 7, maintenance and review. What good is a plan if it's outdated or no one can find it?
First, safe storage. All 5 documents have to be stored safely, preferably in a fireproof safe, and absolutely the executor and agent must know exactly where to find them. Do not rely on a safe deposit box that may be legally sealed upon your death.
That's a great tip.
Second, you must commit to regular review. Life is constantly changing, and laws are changing even faster. We recommend reviewing your documents every 3 to 5 years, or whenever a major life event occurs.
What are the major life events that mandate an immediate legal review, not just a casual check?
Any marriage or divorce is mandatory. Birth or adoption of a child, death of a beneficiary. If you move to a different state, you must review everything because the laws are different.
Right.
Starting a business, retiring, or experiencing a major change in your financial situation, like a big inheritance, also requires an immediate legal update to ensure your plan still reflects reality and is, tax efficient.
We've seen throughout this complex 7-step process that estate planning involves intricate legal processes, jurisdiction-specific laws. It's clearly too important to rely on some online one-size-fits-all form, which brings us to the value of professional guidance.
Right. Estate planning is too critical to get wrong because the consequences of failure are borne entirely by your grieving family. A qualified lawyer provides invaluable guidance and ensures a solid legal foundation.
What specific value does a lawyer bring beyond just drafting the paperwork?
Well, they ensure the legal validity of all 5 documents, making sure they accurately reflect your wishes without any contradictions. They provide specialized expertise, helping you understand complex tax implications.
And they guide you on that fiduciary duty you mentioned.
Crucially, yes. They explain the legal obligations of your executor and trustee, and they guarantee compliance with your state's laws on signing, witnessing, and notarization. They also tailor complex documents like durable POAs to make sure banks will honor them immediately.
So let's talk about the cost, because that's often the highest barrier to entry. We're going to compare the typical traditional way of seeking legal counsel with an alternative legal support model. Let's start with the typical way.
The traditional route can be intimidating and very expensive, which is why so many people avoid it. Lawyers typically charge high hourly rates, averaging upward of, $313 an hour or more, depending on where you live,
And that's per hour.
per hour. The upfront cost for just basic planning can be high. Most lawyers charge an average of $1,500 just to draft a basic will and estate plan package.
And if you add a living trust to that,
That cost can easily climb to $3,000 to $5,000 or significantly more for complex estates.
that initial price point is what stops most people from ever starting.
Yeah.
And you're paying per issue, right?
Exactly. It's transactional. If you have a question next year or you need an update because you had another kid, you start the clock again and you pay that high hourly rate. You're constantly researching law firms, comparing costs, and that engagement usually only covers you, not your whole family.
Okay, so now let's look at the alternative model you sourced, which seems designed to address those three main barriers: high upfront cost, complexity, and that lack of maintenance.
This model uses a predictable, low monthly fee structure. For example, a preferred plan can start at a set monthly fee, like $35.95 per month.
A monthly fee.
And the significant feature here is that this membership includes having a provider law firm draft the three core foundational documents: the will, living will, and power of attorney, at no additional charge. That removes the high initial barrier.
So those three cornerstone documents are included. What about family coverage, which we identified as a major need?
The basic plan covers the member and their spouse. The preferred plan expands that coverage significantly to include the member, spouse, and eligible dependent children under 26. So an entire family can get consultation and those core documents drafted for one flat monthly rate.
And what about updates, which we stressed are vital? If I get divorced 5 years from now, am I back to that $313 hourly rate?
No, as long as you're a member, you get consultation and advice on an unlimited number of personal legal matters. Furthermore, the plan includes an annual review and update of your basic estate planning documents, the will, living will, and POA once each membership year.
So it's like preventative legal maintenance.
It is. It virtually eliminates the worry about having an outdated, invalid document.
What about those more complex services, like creating that living trust, which we know is crucial for probate avoidance?
For complex services like drafting a trust, the provider law firm offers discounted rates, typically 25% off their standard hourly rates. So you can still get the necessary expert drafting, but at a significantly reduced cost.
And you can get access quickly.
Very quickly. You can often speak to a lawyer in as little as 4 business hours. And the service includes other perks, like the lawyer writing letters or making phone calls on your behalf for other personal legal issues or reviewing documents like leases or contracts.
The comparison is pretty stark. The typical model is transactional. You pay high fees only when you need it. The alternative model favors ongoing maintenance, unlimited consultation, and removing that high initial investment.
It shifts the focus entirely. Instead of avoiding the lawyer because of the cost, you're leveraging them for regular proactive maintenance. And that's exactly what you need to keep a plan legally compliant and effective over decades of life changes. #TAG outro.
We have covered a tremendous amount of ground in this deep dive. We started by defining the estate and understanding the genuine, expensive, and emotional threat of dying intestate, where the state dictates your family's future. We detailed the 5 pillars of a comprehensive plan: the will, trusts, the probate avoidance tool, power of attorney for financial control,
The healthcare POA, which is your medical voice, and the living will for your end-of-life wishes.
and we walked through the 7 crucial steps required to build and, crucially, maintain that plan, highlighting the absolute necessity of funding a trust and correctly selecting agents and executors.
Who have that strict fiduciary duty.
Right. But the main takeaway, as we close, is that the true benefit of estate planning is far greater than just saving money on taxes or probate fees. It's the peace of mind you are giving your family.
It is. It's the elimination of emotional, gut-wrenching decisions and conflict for your loved ones during what will already be the most difficult time. You're ensuring your wishes are known and honored and that your life's work is transferred efficiently and privately.
We've seen how essential it is to define your wishes for assets in end-of-life care. But as technology and digital assets evolve, with cryptocurrency wallets, encrypted passwords, social media accounts, The legal landscape is scrambling to catch up.
The concept of physical property is fading.
So as you reflect on your own plan, here's a final provocative thought. How might the role of the digital executor, the person managing accounts, crypto, and complex proprietary passwords become the single most challenging, most frequently updated, and potentially most expensive piece of the estate plan in the next decade?
It's something everyone needs to solve before the assets become irretrievably locked. A critical question for the modern age. Thank you for joining us for this essential deep dive into estate planning.
Until next time.